She asked the court for leniency after failing a drug test. But when the judge uncovered conflicting statements, the hearing...
Your Honor, I'll address this right now. We have no excuses. We will not.
Mr. Allen.
We will not and will never mislead this court. She takes full responsibility for her actions. She thanks this court for allowing her to remain out of custody and to continue to test. You have been fair with her. You've been sympathetic with her. She sincerely apologizes for her actions. I hope the court sees that there is something to be said about her appearance here today to take responsibility. And this is her first positive test since her very first test back in November.
Well, except for the fact that I have abnormal creatinine.
I know
throughout all of these tests.
Yes, Your Honor, that is absolutely true.
Okay.
I don't know what the creatine is. I don't know what could cause
but
creatinine, whatever. I don't know what that is. But I do know what cocaine is, and that is
okay. Well, I don't know if you should say that out loud, but go for it.
I do know that she did test for cocaine on her last attempt on the 9th, and the last time she's tested.
I will usually see abnormal creatinine so that you know when somebody is masking a test. Not always the case. So you can place in perspective that I have this test, abnormal creatinine, and then finally it almost appears wasn't masked enough and the cocaine gets picked up.
Understood, Your Honor. We've been doing this for enough time to know that. I just want to let you know.
You have been doing it, or are you saying me?
You, Your Honor.
Oh,
I know.
so now you're calling me old. Go for it.
Oh,
Keep going. You're doing well.
didn't mean to do that. Your Honor, I just would ask this court any leniency possible. I know you know her situation.
I do, but the problem is that then come here today saying all of that, but that's not what she told community correction.
Well, Your Honor,
She denied use to community correction.
Your Honor, she's stating that she did not deny use. Okay, there's a positive test. That's what we're here.
Hold on a second. You want me to get community corrections over here?
Would that help?
Not you, I don't think. She's denying use to community correction. You have the report in front of you, counsel?
Yes, I do.
Look at the box.
Yes, I
What's
see
it say?
It says denies use. That was,
She's saying that didn't happen.
yes.
So she admitted use.
Now she's admitting use.
No. But she's talking to community corrections. What did she tell community corrections?
Can I speak?
You can do it. Hey, it's
So
up
when
to you.
So before Agent Carr called, the lady called and said it was a illicit drug. I told her I didn't know what illicit. I said, "What is illicit drugs?" And she said, "I can't tell you the exact what it is. Call your agent." And when I called Agent Carr and she said what it was, I told her okay. So I never denied it, but the lady that called from the lab called and just said illicit drugs. And I didn't know what illicit drug was. So that's probably what I came in contact. But I mean, you could ask Agent Carr. I definitely didn't deny use once I talked to her.
So then how did the cocaine get in your system?
What you mean? How did you get in my system?
Yeah.
Okay.
When?
I like, I don't know, a couple of days before.
Anything else?
And the abnormal creatine, I mean, that pops up. I have kidney problems. So that I got a report on it. That's what she wanted. So, I mean, that's been in a lot of my tests. And all the stuff still pops up. It's literally in almost every test that I had, but things still popping up from stuff that I'm prescribed and the cocaine.
Anything else? What are we doing with this case?
Well, Your Honor, I spoke with Mr. Ganatra. He was kind enough to honor the offer made the last PCC. I was just trying to ask this court if it had any leniency for this situation.
To do what?
Excuse me?
What were you asking me to do?
Your Honor, I'm asking for any leniency for this bond violation.
Okay, so on March 14th, she was here. I told her no more missed tests, right?
Yes, you did.
I also gave her an admonishment about how she was treating the people. I'm trying to think at what date I had to do that. Back in December, she was mistreating the people over at Community Correction.
That'd be the 11th.
In December.
Yeah. December 11th, bond violation.
And then don't make it a few months. And then I have to tell her, don't miss tests. And then she tests positive.
Your Honor,
She just seems to do what she wants to do herself.
you wanted me to let you know that she's struggling. And she has a special needs child at home and going through a lot. So
The cocaine helped.
no, obviously not. Look where we're at.
What were you going to do with the case itself? No.
You're right. Oh, go ahead, Mr. Ganesh.
There's a plea offer, but I've not written up the plea form while she's got.
Yeah, that's not going to happen today. How often are you using? Now, young lady, you can, as your counsel has indicated, I guess I'm old and I've been doing this a minute. So you can go ahead and tell me what you want to tell me.
I mean, I don't want to tell you anything but the truth. I take responsibility for it. And
How often are you using?
like you want to is it an everyday thing?
I don't know that that's a hard question.
I have a problem with it. I stopped it and I started back.
Was that my question?
But a couple times.
Okay, look, no. Here's the thing. I don't mind trying to find a way, pretty much everybody in this room that's involved in the system, try to have you work this out and try to assist you to try to get past them. But if you don't want to answer my questions, you want to skate around everything, I don't have time for it. So here's what I'm going to do.
Probably a couple of times a month.
Well, now you want to answer me, right? I'm going to adjourn the probable cause conference. I'm going to adjourn it out 1 week to the 18th, 2024 at 9 a.m. This time, given the violation, you can think about what you really want to say. Defendant's bonds revoked, defendants remain. All right. Mr. Zali, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts as criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases? Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration. $500 fine plus court costs mandatory STD testing. You understand that, sir? All right. You understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that? And you understand that the court is not going to try to assist you or help you out in any way? All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that?
Yeah.
Okay, very good. All right. So what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. And the CD provided to the jail staff.
Yeah.
If the answer is no, I don't know how to ask. Okay. Could you put it as somebody? Is that acceptable? Is that okay with you guys? Okay. Thank you so much.
All right.
So that's everything we have.
All right. That's all discovery. Sir, what did you want to do next on this case?
Before I start the trial.
Well, you understand that the next step is not that of a trial?
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay? That's what concerns me. You're charged with a high court misdemeanor. Okay? The next step is that we're at a probable cause conference. The next step is a preliminary examination. Okay? And then if you're bound over, then you're going to go through that process once again on the circuit court level. You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Just move forward and just not guilty. Case what preliminary examinations. It's okay. I have this matter. I'm in custody right now. And I was hoping to solve it.
So you want it? You got a copy of the police report, right?
I got the discovery. I did. It was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, I'm trying to get the trial done as fast as possible, but if the preliminary examination goes before that.
Wow. Set preliminary examination for April 23rd, 2024, 9 a.m. That will be before me. That's in person. Right.
In this matter, the custody includes
Pardon?
The other day to the arraignment, I was hoping to get released, but there was I had to come here first. Kind of make released through
What do you mean you?
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file. He has been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was arrested on April 5th, 2024. He was publicly looking at inappropriate photos of women in the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is a CSC. He's out on bond in a CSC case while he's engaging in this behavior. At the very least, the ongoing trespass is a violation of his bond, given that he's committing a new crime while he's out on bond, and not concerning behavior engaging in a public place, in a place he's in trespass. My office denied the warrant request, and essentially turned to this case and for us to move forward on violation here instead.
All right. Sir, you are entitled to a hearing regarding a bond violation on this matter. Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was, they said that it was, when they came out and gave me the trespass, when I got here, the process, the trespasses and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because what the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Okay, yeah, there was nothing inappropriate besides being in the library. Yeah, no, nothing weird in the library. I have no idea. But yeah, I wasn't.
But you weren't supposed to be back on the property.
That's what they said. I guess that was suspended from this.
Do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
But I mean, if it's not a new charge, I admit that I was trespassed. That I was probably trespassing there. I was hoping to get out of jail every day.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever. I'm not.
Right.
Well, you just admitted to the violation. That's why I'm worried about you not having an attorney. Just, you admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
I've never been there before. I wasn't aware that I wasn't allowed to be in a public library. I've never been in the building before.
Sir, did you want a hearing on the bond violations? Because I'm going to take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just the bond and stuff we can get heard. Simple as that. I've done like 10 days in jail already. And
where are you coming up with this 10 days in jail?
just got out.
Yeah, but what do you mean I've done my 10 days?
I've done 10 days so far, and I've not actually had the charge. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
but sir, you understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, so the tether.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
So do the best I can. I've been 2 months without a problem. Do the best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you're going to have a hearing on it. But then the issue becomes, are you going to try to handle this hearing yourself? Or are you going to want an attorney to assist you with that? I understand that you want to move forward, but there's going to be a hearing that's going to determine whether or not you're in custody. Pardon?
As soon as possible.
Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Just like I said, I'm just doing my best to live my life.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case. Bottom line, I could come to the decision, okay, well, I'm going to let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's going to be held on this case. I'm going to I'll give him a bond of some type, but he's going to be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope to get out as soon as possible. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself, where one side of it, you might get released, the other side of it is you might be locked up for the remainder of this case? Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just get out the facts.
Just answer my question.
Yeah, just
You're gonna handle it yourself.
God's hands, hope that everything.
Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here?
The answer to that question, I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then because the following week is what day?
So we would have Tuesday morning available,
The
but
16th.
he's in custody, so I would do that. Because that's pretty much he's in custody. Once we did it,
What? I got stuff Tuesday afternoon.
we have an expungement docket at 1, which is small, so we can do it at 2 o'clock.
I could do it at 2 o'clock on Tuesday, the 16th.
It's a U of M police officer, so I can email him, 2 U of M police officers, so I can email them and see if one or both of them can be there on that date.
Okay. What I'll do I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So set a bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender condition. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe, yeah, I can't afford cash bonds, just right, be around on maybe time that I've got it, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so, all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you.
This hearing was a powerful reminder that in court, credibility can matter just as much as the evidence itself. Judge Simpson made it clear that accountability starts with honesty, and when a defendant avoids direct questions or violates the court's trust, the consequences can escalate quickly. Whether it involved a bond violation or inconsistent answers, the court focused on one principle: responsibility. Cases like this show that every statement and every decision inside the courtroom can influence what happens next. Do you think the judge made the right call by revoking the bond, or should the defendant have been given one more chance? Let us know your thoughts in the comments.